Legal dictation, 80 word per minute. Get ready. The appellant and respondent were duly married on 26 April 2007. Unfortunately, after a couple of years, differences started between them, which culminated in a decree of divorce granted by the Family Court Ghaziabad on 20th September 2014. In case number 765 of 2011 on the ground of cruelty. Para. The matter was pursued before the court of Allahabad, leading to the impugned judgment dated 9/9/2015, the High Court confirmed the decree of the divorce. However, regarding the permanent alimony, despite the compromise said to have been entered between the parties for a total amount of rupees 36 lakhs, the High Court reduced the amount rupees 29 lakh. It is not in dispute that an amount of rupees 21 lakh had already been paid by the respondent before the High Court. Learned counsel appearing for the respondent husband submits that pursuant to the order passed by High Court, a further amount of rupees 5 lakh has also been deposited with the family court Ghaziabad. Para. When the matter came up before the court on 4/1/2016, having regard to the submissions made by the counsel for both sides that the parties would like to have a peaceful settlement of the entire disputes. They were directed to appear before this court in person. Accordingly, the appellant, Miss Priyanka Chawla, accompanied her father, Mr. Girish Arya, and respondent, Mr. Amit Chawla, present before the court. It is agreed that in addition to the amount of rupees 21 lakh paid by the respondent husband, a further amount of rupees 5 lakh will be paid within period of 6 months. It is also agreed between the parties that the decree of divorce granted by the family court Ghaziabad on 29/9/2014 be set aside and the parties be granted divorce by mutual consent on a joint petition that is filed by the parties before this court. It is also agreed that all the other civil and criminal litigations between the parties as of now pending in various courts be also put an end to stand quashed. Para. Having regard to the fact that a decree for divorce had already been granted as early as on 29 2014 in the interest of justice and for doing complete justice, the cooling period is waived and the parties are granted a decree of divorce by mutual consent. The appellant is permitted to withdraw the demand draft of rupees 5 lakh deposited by the respondent before the family court, Ghaziabad. The respondent will pay the remaining amount of rupees 5 lakh by way of demand draft drawn in the name of Priyanka, appellant, on or before 36 2016. The court appreciates the sincere efforts made by the learned counsel for the parties for an amicable settlement between the parties and also the cooperation rendered by the parties. If you practice in this way, you will be able to increase your speed. If you like the dictation, please press the button and subscribe the channel. Thank you.